I'm David Scheffer. I'm a professor of law at Northwestern University School of Law, and I'm the director of the Center for International Human Rights there. My colleague Caroline Kaeb and I wrote a paper for this workshop here at the Searle Center that really focuses on 5 levels of compliance that we think multinational corporations should be much more sensitive to and knowledgeable about with respect to corporate social responsibility. This term has been around for a number of years now, but there's still a tremendous amount that is evolving with respect to how corporations can start the process of compliance with human rights norms, environmental norms, labor norms, and anti-corruption norms by working first with their public affairs offices to make sure the right word gets out about the corporate performance in the field. Secondly, to ensure that they have codes of conduct that internally regulate their business so that they don't get into trouble and they minimize the risk of getting into trouble with the law with respect to these very, very important principles of social responsibility. And then we have a fairly substantial discussion about the Alien Tort Statute issue here in the United States, which is unique to the United States but does put corporations at some degree of risk that they need to be fully cognizant of and understand because there is a reason behind the Alien Tort Statute. It has a good reason behind it, quite frankly, but it's a unique one to the United States, and multinational corporations need to understand what those risks really entail. And then we have a 4th level of compliance that really looks to how a corporation needs to ensure that it's filing proper documents with the Securities and Exchange Commission, that it's auditing its books and performance properly so that the transparency of its performance is available for everyone to see so that we all know that they're in compliance with these norms. And I think I'll turn it now to my colleague Caroline to speak about what is really the most significant part of our paper, which is the 5th level of compliance.
Thank you, David. My name is Caroline Kaeb. I'm an adjunct professor here at Northwestern University School of Law, and in our paper we introduce a 5th level of compliance that we define as the ultimate level of compliance where a company makes human rights and social compliance an integral part of their business strategy, and thus making social and human rights issues a market as opposed to a non-market issue. We consider that it's no longer an externality, but really an integral part of their strategic decision making. So as an example, we use the case of Google in China, where Google just recently took a stand for human rights and especially for freedom of expression, and finally made the business decision pulling out of China, illustrating that freedom of expression as a human rights issue is really an integral part of their business strategy in order to perform their core business mission, which is to provide free access to information and free flow of information. So I think I just want to conclude by saying that we argue that this 5th level of compliance, which is the most innovative form of approaching these issues in the 21st century, applies not only to the information and communication industry, but applies to all enterprises across various industry sectors. Why? I just want to refer to Hillary Clinton's statement a few months ago on this. Why? Because modern business creates and captures business value through information flow in our days. So free flow of information and access to this information is crucial for a company like Google to perform its business mission, but also to preserve the growth and the success of global commerce in general.